is that prior record, and apparently you have one, the state's agreed, you don't have any record of any description. That's, well, a bit unusual up here in Superior Court, and that is a major factor for the court to consider, the fact that you have no priors at all. The other issues that Ms. Stanley has brought up are other factors that the court must consider, and the court is required to make some effort to find some way to ensure that your interests or your rights are protected as well as the law followed concerning your eligibility for bond. As I sit here right now, Ms. Acree, I don't know. I'm sure you've observed I got several other cases to handle today. I'm going to have to consider all of this. And now the other issue is the indictment. Mr. Cannon is absolutely correct. There's a lot of constitutional issues that are going on here as well, and everybody is going to have to be on their toes, doing their job, and doing it very well. This is a high-profile case, very serious charges here, Mr. Cree, as stated by Ms. Stanley, and it'll be treated as such. So, Mr. Cannon, I want you to get a formal brief to me about the indictment, and Mr. Cree, I'll make a ruling on the bond the first chance I get. I'm not going to promise it's going to be today, but anyway, I'll get it moving. All right, anything else on this one, Ms. Stanley?
Yes, I have one question for you. Since this defendant's in a little bit different of a position with the previous bond, do you want me to go ahead and put that part on the record?
Yeah, go ahead.
Okay. So I did go over to magistrate and pull that bond. She bonded out, it looks like on a $10,000 bond, and the charges at that time looks to be 4 counts of 42-518, 1 count of possession of marijuana less than an ounce, 1 count of possession of tools for the commission of a crime, 1 count of possession of a Schedule I, and 2 counts of criminal solicitation. It's the state's position that that $10,000 bond could apply in this case, but the issue that we are faced with here is that due to the special presentment indictment, she's now been indicted on 3 counts of racketeering activity. Even though these charges that she bonded out on are related to that, that bond was not for these charges. So there would have to be a bond for these new charges, but the old one could apply towards it.
So that's still in the warrant phase. It's never been indicted.
This case, the RICO is incorporating that. Yeah.
So that was a warrant only.
It was. That's why I said the same alleged conduct.
Gotcha. I understand. All right, Mr. Cree, that's it for today. You'll be notified, of course, by Mr. Cannon. I'll send my ruling to Mr. Cannon, and I'm sure he'll take it from there. But that's it for today, Mr. Cree. You are excused and can be returned to the back. Thank you, ma'am. All right, Ms. Riedel, you ready? Sure. All right, let's bring up Mindy Fordham, please. And she is... Wait a minute. Oh, there we go. Number 7. There we go. What's that? Letter Q. All right, let's get on the record. This is case number 25R127Q, as in Quebec-MJ, State versus Mindy Jane Fordham. That's you?
Yes, sir.
I'll note for the record that Ms. Fordham is seated at council table with her attorney, Ms. Sarah Riedel. Ms. Fordham, your case is before me today on a bond issue. And by the fact that we're all sitting here to start a hearing, the state is opposed to bond. Is that correct, Ms. Stanley?
Yes, Your Honor.
All right, go ahead and give me your reasons, and then I'll hear from Ms. Riedel.
Yes, Your Honor. As I have put on the record previously, this defendant wouldn't be entitled to bond because her case is indicted. The 90-day rule wouldn't apply. As far as Ms. Fordham goes, she is charged with 3 counts of racketeering activity, trafficking, multiple counts of gang activity, possession of marijuana with intent, and multiple counts of criminal attempt. As I stated previously, under the gang statute, which is 1615-4, that does require increased bail for the gang charges, as well as the special conditions that they should not have contact of any kind or character with another member or associate of a street gang. If the court is inclined to set a bond, I would also ask the court to set it at no less than $300,000 with the special gang conditions and the special condition that she be banned from DOC properties. I have had a chance to look, and just to put this on the record like we did with the last one, her PI case, we actually came before you on January 17th of this year, it looks like, and we had a bond hearing. At that time, you set a $250,000 bond. Those charges look to be trafficking, possession of ecstasy, 42-518, looks like possession of marijuana, possession of tools for the commission of a crime, and then another count of 42-518. So as I had just stated, the state's position is that that $250,000 could apply to this now indicted case, but we would just need to set a bond on the charges that she does not have a bond on. And I also have had a chance to look at her history. In 2010, it looked like there was giving false statements to law enforcement. Again, without getting into the facts other than what's necessary for this, this is a situation where Ms. Fordham and the co-defendants were part of an enterprise who is illegally smuggling drugs into Telfair State Prison. And so for those reasons, I believe that she would pose a significant risk to commit other felonies. And due to trying to get the drugs into the prison, I believe she would pose a significant threat or danger to the community. So for those reasons, we would be opposed.
Ms. Riedel.
Judge, I was pretty animated when I was here before because this to me is just ridiculous. My client has been in jail for 17 months now. She was in jail for 16 months before she was ever even indicted. And now she's indicted on charges that we didn't even know about and still don't know about because we have a sealed indictment. So I want to put it on the record, we need the indictment. I think we're entitled to this indictment, and the court needs to get this indictment released to us immediately. It's kind of hard to sit here and argue a bond hearing, but I don't even know what she's charged with, but I want to laugh when we're talking about gang charges. I'm looking at my client, and I think this is hilarious. I mean, it's serious charges, but ridiculous. This is as close to, and I don't have the law on this at this point, it's just because I didn't prepare for this exactly, but it looks to me like that this is what you would call prosecutorial vindictiveness, prosecutorial vindictiveness and vindictive prosecution. When I was here in January, we argued that there was crazy bond of $250,000 because this lady has nothing. And as the court knows that the law is clear that a bond that is beyond the reach of a defendant is as if they have no bond at all. And there's all sorts of constitutional issues being, to me, being breached in this case. I mean, my client now, after being in jail for 17 months, we still don't know what the charges are. We don't know what the basis of the charges are. The severity of the charges have obviously been increased. It's basically a denial of her constitutional rights to sit in jail for this long, and we're unable to give this client a fair proceedings in any court of law when we have this kind of prosecutorial conduct. It just appears to me that in 17 months while a lady is sitting in jail, it should have been known well before then what her charges should have been. And to have her sit in jail this long and then suddenly change it, and now she's apparently on indictment with I don't even know how many charges. I mean, I guess I could count them, but it's a whole bunch of them. And of course, we haven't had the ability to read them. I had filed a motion to reduce the bond previously because when I called to find out whether or not she had been indicted, of course, we didn't have an indictment because it's sealed. So I was told no, or my office was told no. So we asked to reduce the bond, which is what this court had agreed that we could do immediately upon no indictment. So then we get to court and learn that, yes, there is an indictment, but you can't see it because it's sealed. It just seems to me that I understand that we have to protect law enforcement. I get this, but we have to protect constitutional rights of our defendants. And I don't think we're doing that in this court right now. I'm pretty frustrated with this. I know that this is not the trial in this case, but we go on what the state gives the court a recount of what the charges are as if they're what is the truth in this case. And so I think that the defendant should be given that same ability. My client, we don't even know this person, Antoine somebody or another, who had the drone and where all the drugs and all of this stuff was for Antoine Hurst. We don't even know who this person is. I don't even know where this person is from, probably Atlanta or somewhere. We don't know. We don't even know who he is. It's unfortunate if you happen to own property or be on property that's close around where people shoot off drones or fly drones, whatever you do with them. It's unfortunate when you find yourself in that mess. And she's not the only one that's back there in a jumpsuit for this same reason. But I understand that we're not here to try the case. I get it. But we're going to be here to try this case really soon because this defendant is going to demand a speedy trial the next term of court. This is outrageous that she has been in court this long. So we are certainly asking for a bond, and we're asking that the bond that she had be reduced because she couldn't make that bond she has nothing because she's lost everything she had because she's been in jail for now 17 months. But before she lost everything, she couldn't make that bond if she sold everything she had. So it is actually the same as no bond at all.
All right, Ms. Fordham, there's a couple of things I want to get on the record. And after listening to Ms. Riedel, I remember back in January, I'm going to repeat a lot of what I told you back then, is that today is not the trial.
Yes,
On a
sir.
bond hearing, the court is required to consider essentially the 4 factors for a bond. And we've gone over these before, but prior convictions is one of the factors. Apparently, you have no prior felonies at least. And Ms. Riedel makes it very clear that you are not any sort of a flight risk. You wouldn't have anywhere to go even if you wanted to.
Yes, sir.
So that doesn't appear to be an issue. And you heard the state's position is they seem to have the position or the feeling that you might violate some of those bonds or be a risk should the court grant you a bond or at least put a bond with a number on it that you could post. Now, I've got to factor all that together and make a decision
Yes,
about,
sir.
at Ms. Riedel's request, whether to reduce your bond or set a number at which you can actually post. And as I sit here right this second, I don't know what I'm going to do.
Yes, sir.
As though you can plainly see, I've got other people to attend to. And once I get through with it all today, I'll sit down and gather up my thoughts and make a ruling. Now, the other issue about the indictment, Ms. Riedel, is I know you sat through the previous hearings. I want you to brief it as well. As Ms. Riedel has said, Ms. Fordham, she is very animated about this, and, well, that's fine. I'm glad to see it. You got a zealous advocate on your part, and that's exactly what you need because these are very serious charges, as I'm sure you know. Ms. Riedel seems quite confident that you've got a lot of things going in your behalf for trial.
Sure.
And if that's where we go, that's where we go. But Ms. Riedel, I want you to brief it. Everybody's going to need to do their job on this case. This is a high-profile case. It's already getting a lot of attention. And I'll make a ruling after you get your brief in on the releasing the indictment, or at least portions of the indictment. So that's going to be it for today, Ms. Fordham. I'll notify Ms. Riedel in writing of my decision.
Yes, sir.
You are
Thank you.
excused.
Thank you, sir.
Thank you.
Any other business, Ms. Riedel?
No, sir.
All right, well, you're excused if you want to leave, but you're welcome to stay.
Thank you.
Okay. Ms. Cameron and Mr. McLaughlin, do you want to do yours separately or two at the time, or how do you want to do it, Ms. Cameron?
I don't care, I just want to go first.
Who is it, Ashley?
I don't care, CJ, what's his name?
Williams?
Courtney Collins is the first one?
Okay.
Oh, okay, never mind, I ain't got that person.
My list says you have Holly Moore and Patrice Williams, Mr. McLaughlin.
Now, I don't have Patrice Williams today.
All right, hey, I didn't know she was even existed until I got here today. All right, Mr. McLaughlin, let me be clear. Who do you represent?
I know for sure I represent Holly Moore right now.
Okay.
All right,
That's
let's do that one. Get
almost
Ms.
identical to the young lady.
All right, get Holly Moore out, please. And that is number 4.
Ms. Moore. Sit right there.
Next up is position 4 on my bond calendar, case number 25R127M, as in Michael-MJ. You are Holly V. Moore?
Yes, sir.
All right, Ms. Moore, I'll note for the record that you are seated at council table with Mr. McLaughlin. Ms. Moore, your case is down today on my calendar for a bond hearing. By the fact that we're all sitting here today, I'm presuming the state is opposed to bond. Is that correct, Ms. Stanley?
Yes, Your Honor.
All right, well, go ahead and give me your argument, and then I'll hear from Mr. McLaughlin.
Yes, Your Honor. As I have put on the record previously, Ms. Moore wouldn't be entitled to bond because her case is indicted. The 90-day rule wouldn't apply. Ms. Moore is charged with 3 counts of racketeering activity, trafficking, multiple counts of gang activity, possession of marijuana with intent, and multiple counts of criminal attempt. The state is going to be opposed to bond in this matter today. We believe that Ms. Moore poses a significant risk to commit other felonies pending trial, as well as poses a significant threat or danger to the community. As I stated previously, under the gang